came in at 6:14 a.m. on a Tuesday. I know the exact time because I was already awake, already on my second cup of coffee, already reviewing schematics for a Phase 3 rollout that wasn't due until Thursday. That was just how I operated. 21 years of that. 21 years of being the first one in and the last one out. The person who stayed late when the servers went down, who flew to Cincinnati on Christmas Eve because a client's infrastructure was failing. 21 years of being the kind of employee companies write case studies about. The email was from my new boss's assistant, not from him directly, his assistant. It said, "Please be available for a video call at 9 a.m. today. Calendar invite to follow." No subject line, no context, just that. I remember sitting there for a second, reading it twice. My wife came downstairs while I was staring at it. She asked if I wanted more coffee. I said sure. I didn't mention the email. I didn't want to say anything until I knew what it was about, because something in my stomach had already started to move in a way I didn't like. I've been with Halcyon Systems for over 2 decades. I joined when it was still a mid-sized regional firm doing network infrastructure for hospitals and municipal contracts. Back then, the founder, a man named Mr. Aldrich, ran the whole operation out of a converted warehouse in Columbus, Ohio. 30 employees, 2 conference rooms, and a coffee maker that made a noise like a dying engine every morning at 7 a.m. I love that place. I don't know how else to say it. I love what we were building. Over the years, Halcyon grew. Mr. Aldrich made smart acquisitions, hired good people, and eventually took the company to around $400 million in annual contracts. I grew with it. I started as a senior infrastructure engineer, moved into lead architect, and eventually became the chief systems architect. 17 patents had my name on them. The core diagnostic framework that underpinned Halcyon's flagship product suite, the thing that made us competitive against companies 3 times our size, that was mine. Well, that was what I believed at the time. The call started at 9:02 a.m. My new boss, a man I'll call the director, he'd been brought in 8 months earlier from a private equity firm in Chicago, appeared on screen in what looked like a hotel room. Behind him, there was a window with the kind of generic skyline view that could have been any city. He was maybe 42. He had the kind of confidence that comes not from knowing things, but from never having been wrong in front of anyone who could correct him. He said, "Thanks for making the time." I said, "Of course." He said, "I want to be straightforward with you. We're restructuring the technical leadership layer. Your position is being eliminated." I didn't say anything for a moment. He kept going. "This isn't a performance issue. We're moving toward a consolidated model, and we've decided to bring in an external team to handle architecture going forward. We appreciate everything you've contributed." That last sentence, "We appreciate everything you've contributed." I had heard those words before, in exit interview guides and HR training manuals. They were the sentence you said right before you handed someone a box. I said, "Who made this decision?" He said, "It came from the top." I said, "Mr. Aldrich approved this?" There was a pause, just a half second, but I noticed it. He said, "Mr. Aldrich is transitioning out of day-to-day operations. His son has taken over as CEO." That was the first time I'd heard that. Mr. Aldrich had a son, a young man I'll call the CEO's son, who had been working at a venture capital fund in San Francisco for the last few years. I'd met him once at a company holiday party maybe 6 years ago. He'd shaken my hand and asked what I did. When I told him, he nodded in a way that suggested he had already moved on mentally to the next conversation. I said, "Is there a severance package?" The director said his assistant would send over the details. I said, "All right." I closed the laptop. My wife was standing in the doorway of my home office. She'd heard enough. She didn't say anything yet, just walked in and sat in the chair across from me. We've been married for 26 years. She knows when to talk and when to just be in the room. After a while, she said, "What are you thinking?" I said, "I'm thinking about a folder on my external hard drive." She looked at me for a moment. Then, slowly, she nodded, because she knew exactly what folder I was talking about. Here's something most people don't know about the way intellectual property law works in this country, and it's something my father drilled into me before I ever took my first corporate job. My father was a machinist, spent 30 years working for a manufacturing company in Dayton. He designed a tool fixture that ended up being used in every one of their facilities across the country. He never saw a dime for it, never had any claim to it. He'd signed a standard employment agreement that assigned everything he created on the job and a significant portion of what he created off the job to the company. He died knowing that something he built was generating revenue he would never touch. Before I joined Halcyon, my father sat me down at the kitchen table and told me that story. He told me to read every line of every contract I ever signed. He told me to keep records of everything. He told me that the work you do before they own you is the work that belongs to you. I had listened. In the summer before I accepted Halcyon's offer, I had been working independently on a diagnostic architecture framework. I was consulting at the time, going between 3 or 4 clients, building a methodology for predictive failure analysis in distributed networks. I had documented everything. I had filed a provisional patent application through a patent attorney I found through a bar association referral. The provisional was filed on September 3rd. I signed Halcyon's employment agreement on October 19th. 46 days. Their standard IP assignment clause, like most standard IP assignment clauses, covered inventions made during employment and inventions made using company resources. What it did not, and legally could not cover, was work that was independently developed prior to employment and documented with a prior filed patent application. When Halcyon built its flagship diagnostic suite, they built it on top of my framework. Not similar to my framework, on top of it, using my methodology, my architecture, my variable classification system. I had watched it happen over years, piece by piece, always telling myself it was fine, because I was employed there, and the work was continuous, and everyone was collaborating. I had told myself the lines had blurred enough that it didn't matter. But the lines had not blurred on September 3rd. The lines were very clear on September 3rd. The folder on my external hard drive contained the original documentation, the provisional application with its timestamp, the correspondence with my patent attorney, and a full technical comparison I had assembled quietly over the course of about 18 months. Beginning 3 years into my time at Halcyon, when I started to understand how foundational my pre-employment work had become to the company's product. I had never done anything with it. I want to be honest about that. I wasn't sitting there waiting to pull a trigger. My intention had always been to let it stay in that folder, because I liked my job, I respected Mr. Aldrich, and I wasn't interested in litigation. I was interested in doing good work. But now, Mr. Aldrich was stepping aside, and his son had just had someone else call me at 9 a.m. to tell me I was done. I called my patent attorney that afternoon. He'd been practicing IP law for 31 years. He remembered the original filing immediately. When I explained the situation, there was a silence on his end that I recognized as the kind of silence a person makes when they are being careful about what they say next. He said, "You still have all the documentation?" I said yes. He said, "And the diagnostic suite, they've been commercially licensing it?" I said yes, to over 200 healthcare systems across the country. He said, "And the pre-employment filing date is unambiguous?" I said yes. He said, "I think you should come in." I went in the next morning. We spent 4 hours going through everything. He brought in a colleague who specialized in technology licensing disputes. By the end of the meeting, the picture was clear. The original diagnostic framework had been developed and documented before my employment. Halcyon had built commercial products directly derived from that framework. Their IP assignment clause could not retroactively apply to work that predated the agreement. Under the circumstances, every licensing contract they had signed using that product suite was built, at least partially, on intellectual property they did not own. The number my attorney put on the table was not $740 million, like the video title of that other story you might have seen, but it was significant. North of $500 million in accumulated licensing revenue over 18 years, with ongoing contracts worth considerably more. My attorney sent a formal notice to Halcyon's legal department on the Thursday. By Monday morning, I had 3 missed calls from a number I didn't recognize. It turned out to be outside counsel they'd hired over the weekend. That told me everything I needed to know about how seriously they were taking it. The next 6 weeks were the strangest of my life. I want to describe them accurately, because I think people sometimes imagine that moments like this feel triumphant. They don't. Or at least this one didn't. It felt like standing in a field during a storm, watching something you built for a very long time get assessed for structural integrity by people who had no idea how it was built. Halcyon's legal team pushed back hard. They argued continuous development. They argued that while the provisional predated employment, the finalized patent and subsequent iterations were developed during my tenure, my attorney had anticipated all of it. The key was the core classification architecture, the foundational logic that every iteration had built upon, which traced directly and demonstrably to the pre-employment documentation. I also want to say something about the CEO's son, because I think it matters. He called me personally at some point during week 3. I hadn't expected that. I had expected more lawyers, more letters, more conference calls with people I'd never met speaking in the careful, passive voice of institutional liability management. Instead, it was just him calling from what sounded like his office. He said, "I want to understand what you actually want here." I said I wanted the matter resolved fairly. He said, "My father didn't know any of this." I said, "I know he didn't." He said, "He's not doing well. I need you to know that this isn't what he would have wanted." I believed him. Mr. Aldrich had been my mentor in a lot of ways. He was the kind of person who remembered your kids' names and your wife's birthday and what you told him 3 years ago about a project you were excited about. The decision to let me go hadn't come from him. It had come from a restructuring strategy designed by people who saw Halcyon as a portfolio asset rather than a company built by human beings over decades. I said, "I don't want to hurt your father's legacy. That's the honest truth." There was quiet on the line. He said, "Then what does a fair resolution look like to you?" My attorney and I had talked about this at length. We weren't interested in dismantling the company. The diagnostic suite was being used by hospital systems and healthcare networks that served real patients. Pulling licensing agreements apart or seeking injunctive relief that disrupted operations was not something I wanted on my conscience, regardless of what the legal merits allowed. What I wanted was acknowledgement and fair compensation. A licensing structure that recognized the origin of the framework. That compensation for the years the work had been commercialized without proper attribution or agreement. And a forward-looking arrangement that treated me as what I had always actually been, not an employee who had signed away his work, but an originating architect whose foundational contribution deserved to be reflected in how the company operated. The negotiation took another 4 months. There were days when it felt like it might collapse. Halcyon's board brought in the new outside firm at one point, and we had to restart several threads of conversation. My attorney stayed steady throughout all of it. My wife stayed steady throughout all of it. She had taken to making a large pot of soup every Sunday evening and leaving it on the stove for the week, which sounds like a small thing, but was, in practice, an act of profound stability. Soup on the stove means someone is holding the house together while you are somewhere else in your head. The final agreement was sealed on a Friday afternoon. I won't disclose the specific terms because they are confidential, but I will say that it addressed everything I had asked for. Retroactive compensation, a formal licensing structure with my name attached to the originating work, ongoing royalty arrangements, and a written record acknowledging the pre-employment origin of the core diagnostic framework. When my attorney called me with the final confirmation, I was sitting in my father's chair. The one from the house I grew up in, the one my mother had given me after he died. Brown leather, worn armrests, the kind of chair that holds the shape of someone who is no longer in it. I had moved it into my home office years ago. I sat in it sometimes when I needed to think. I thought about him. I thought about that kitchen table conversation. I thought about the tool fixture he designed that made money for 30 years without ever having his name on it. I thought about how he never made a big thing of that story. He didn't tell it bitterly. He told it the way a person tells you about a road condition, not to complain, but to help you navigate. He'd given me the map. I called my wife into the office. She sat across from me, same as she had on that first morning when I closed the laptop and said I was thinking about a folder. I told her it was done. She didn't say anything for a moment. Then she said, "Your father would have thought this was something." I said, "Yeah." She said, "He really would have." I've thought a lot since then about what I would tell someone else in a similar position. Not about the legal mechanics, your attorney handles that, but about the personal mechanics. Because the hardest part of all of this wasn't the negotiation. It wasn't the uncertainty, or the stress, or the months of not knowing. The hardest part was the early decision about what kind of person I wanted to be through it. Whether I was going to approach this as revenge or as something else. I decided early that I didn't want revenge. Revenge would have meant going in hard, filing for injunctive relief, trying to disrupt their licensing relationships, making the whole thing as painful as possible for as many people as possible. I could have done that. There are attorneys who specialize in exactly that approach. But there were engineers and developers and support staff at Halcyon who had nothing to do with the decision to eliminate my position. There were hospital systems using the diagnostic framework to monitor patients. There were people in the middle of this who had never done anything wrong, and I was not willing to treat them as acceptable collateral in a war I was waging against people who had. What I wanted was what the law had always entitled me to, nothing more and nothing less. There's a difference between those two things that I think gets lost when people tell stories like this. The satisfaction isn't in the burning down. The satisfaction is in the quiet, documented, carefully maintained truth that you've been carrying in a folder for a very long time, and the moment when the right people finally open it and understand what they're looking at. My father built something that made money for 30 years without his name on it. Mine has his name on it now. And mine. If you've been in corporate America long enough, you know that the system is not designed to protect the people who do the actual building. It's designed to protect the structure. And the structure will tell you that your loyalty is an asset, right up until the moment it becomes inconvenient. And then it will have an assistant send you a calendar invite for a 9 a.m. call and tell you it appreciates everything you've contributed. Read your contracts, keep your records, understand what you created before they owned you, and if you're lucky enough to have someone sit you down at a kitchen table and tell you how the road actually works, listen to them. I still sit in that chair when I need to think. I still think about that kitchen table. The way my father sat across from me, not angry, not bitter, just clear. He had lost something real and he wanted to make sure I didn't lose the same thing the same way. That's what integrity actually looks like in practice. Not speeches, not slogans. A man sitting down at a table and telling his kid the truth about how the world works, even when that truth cost him something. What happened to me at Halcyon wasn't complicated once you stripped away the legal language. I built something before they owned me. I documented it, protected it, and then I went to work and gave them 2 decades of my best effort anyway. Not because I was naive, but because I believed the work itself was worth doing. That belief was never misplaced. The work was worth doing. The people I worked alongside were worth showing up for. What wasn't worth surrendering was the record of what I had created before any of that began. There's a version of the story where I become someone I wouldn't want to be, where the termination call at 9:03 a.m. becomes fuel for something corrosive, where I walk into that negotiation wanting to burn things down and make people feel what I felt when the director's assistant sent me a calendar invite instead of a conversation. I understood that impulse. I won't pretend I didn't feel it on that first morning when I closed the laptop and sat there in the quiet. But I kept coming back to the people in the middle. The engineers who had nothing to do with the restructuring decision. The hospital systems using the diagnostic framework to monitor real patients. The moment you stop being able to see those people clearly is the moment your grievance has eaten your judgment. I wasn't willing to let that happen. Keeping those people in your line of sight when you're angry. That takes something. It takes a kind of discipline that isn't natural. You have to choose it deliberately, over and over, every time the easier path presents itself. And the preparation, the folder, the attorney, the documentation going back decades, that didn't come from luck. It came from listening carefully to someone who had learned a hard lesson before me and was generous enough to pass it forward. My father gave me that. He gave me the understanding that your mind and your work are yours to protect, and that protecting them requires patience, rigor, and the willingness to do the unglamorous work of keeping records when nothing is wrong yet, precisely because something might go wrong later. That's what I'd want someone to take from this. Not the settlement, not the legal outcome. The habit of protecting what you build, the character to pursue what's fair rather than what feels satisfying, and the endurance to hold both of those things together for as long as it takes. I sat in my father's chair when the call came in, confirming the agreement. I don't think that was an accident. Some things are worth carrying for a long time, the ones your father handed you first.